Welcome to our roundtable today on regulating the platform economy. I'm really excited about this roundtable because it's an opportunity to take all of the years of research that we've been doing on the platform economy and to think really about how it applies concretely to the kinds of struggles and regulatory debates that are currently taking place, both in South Africa and at a global level. In June of this year, the International Labour Organization will be voting, or members of the International Labour Organization will be voting on a new convention for the platform economy, which is the product of years of mobilizations by workers' organizations demanding that these platforms be regulated. The form that regulation has taken place has been uneven and diverse. Kenya, for instance, has been at the forefront of regulating the e-hailing sector, but in many ways that regulation is considered insufficient to extend labor protections to platform workers. South Africa is now debating amendments to the Basic Conditions of Employment Act, the Labor Relations Act, and the National Minimum Wage Act, which may be an avenue to extend labor and social protections to gig workers, including platform workers. So it seems like a good moment for us to get together as workers' organizations. We have employers' organizations in the room, researchers, academics, and government to really think about the challenges of regulating the platform economy. We have, for those of you who are interested, a paper which has a very basic title, Who Counts as a Worker? The Politics of Claim-Making in Africa's Gig Economy, which you can check out. It was done with support from the Department of Science, Technology, and Innovation. But I think that more than this working paper, it raises more questions than it does answers. And so I think that will be the spirit of this conversation, which and the second roundtable. So who do we have lined up? Well, our first guest will be Omar Parker from the National E-Hailing Federation of South Africa, who will be presenting on the basic position of e-hailing workers in their organization and the ways that they've tried to build the organization to respond to the diversity of relationships within the platform economy. You will have 20 minutes to lay out their program, and then we're going to have a series of 3 really interesting discussants. Stephen Ratai from the Department of Employment and Labor, Muzi Singalani, who will be joining from the Department of Transportation, and last but not least, Lanley Simpson from the Department of Science, Technology, and Innovation. All directors within these ministries thinking about these questions from different viewpoints. And I think that that's what we're excited to do and to prod in this particular roundtable, is to have a conversation about the regulation of the platform economy. We will then have respondents, and that will be Pat Horn from StreetNet WIEGO, who has done a lot of work over many years around the gig economy and improving the conditions of work in the sector, and then from Mavis from SATUC, who will be joining us online, I think, as well. And then, of course, there will be time for Q&A. So that's the program for today. Without further ado, I'd like to turn it over to Omar Parker. Omar, over to you.
Thank you very much, Program Director and the facilitators on the program. Let me just begin first and foremost, very briefly, just to say thank you for this opportunity. And my name, I think I have introduced myself already. I'm Mark Parker once more, and I come from a trade union background, spanning over, I would say, 4 decades, serving on, currently serving on a voluntary basis. I've worked with many trade unions, come from the metal industry, and I now serve on a voluntary basis for the National E-Hailing Federation of South Africa, which is an independent organization, and I'm also an active founding member of the Western Cape E-Hailing Association, that's an affiliate of the Federation. And we are also affiliated to the International Alliance of App-Based Transport Workers, who have a footprint in a number of countries in both the Global South and in Latin America, Southeast Asia and Asia. For now, let me just say that I'm not an expert in law, just a general disclaimer. but I will try my best from a worker's perspective based on the collective contributions and the engagement that has taken place within our own organization and also other collaborations in terms of how we partnered in terms of our advocacy. Let me immediately begin to say that this is not this is not easy. I started trying to write this thing. I ended up with 10 pages, but I had to, seek a critique on my own contribution. And I'm not going to confine myself to what I've written, but I will try and speak and address and zoom into the very key critical elements which I believe is of importance. Let me immediately begin to say that, by way of introduction, also further, I think the rise of platform work, in particular in the transport sector, has transformed, the labor market both in South Africa and globally. And in South Africa, this transformation has sparked discussions around regulatory reform to address the unique challenges and opportunities of platform work. And at the heart of this discussion lies the essential differentiation between, I would say, worker, in brackets, employee, because in terms of our legal framework, it's employees and not workers, and independent contractors. And this distinction is critical for ensuring fair labor practices, labor conditions, while fostering innovation, in the economy. Attention has been focusing on defining worker, but this has not been sufficient thus far. And I think we can even see from the experience in Kenya, although Kenya has been quite advanced and to an extent very progressive in moving in the direction of trying to regulate, platform work. Enterprises are responsible, basically, in this situation for disorientating, workers and employees and independent contractors, particularly with regard to its definition, and disrupting, in my view, government's ability to properly regulate, corporate responsibility. Let me immediately begin because as I said, I'm going to try and short-circuit my entire writings and contributions, but I'm going to quickly zoom because there's so much to be covered. And I don't think, given the time, that I will be able to do justice to, what I think needs to come across. But hopefully, I think people have been exposed to a lot of research. People have been able to engage at various levels. And I think my reasonable assumption is that I think there is a fair amount of understanding and knowledge production in this space. Let me just say that I'm going to try and do, and I'm moving completely away from what I said I was initially going to do, but I'm going to try and just speak, because I think I'm going to get a little bit mixed up in my own structure of my writing. I think it's important for us to realize in South Africa that with the advent of Uber within South Africa in 2013, we've seen major disruptions within the labor market. We've seen what that has caused. It has actually added fuel to fire within the South African labor market. We've seen increased tensions between those who have come up in the e-hailing space, for example, and the existing mainstream sort of public transport providers, the traditional minibus taxis and taxis, and even the meter taxis, traditional meter taxis. And that has led to a lot of tensions. It has led to a lot of instability. It has led to a lot of violence. We've seen many deaths. Last year, we witnessed a young driver from Bolt who has been brutally murdered at Maponya Mall. Let me just say, throughout that period, we've seen the emergence of organizations on the ground who sought to respond to this unfolding crisis. And ever since then, the calls have been to regulate the industry. But not only the industry, workers were demanding what was important for them within the workspace. And what we then found was that many organizations, new forms of organizations have emerged. And I must say, the unions have never had a real appetite to organize workers in the space. And so, through self-activity in response to the objective conditions faced by workers, and appalling being subjected to appalling conditions, gross exploitation, by the multinational app companies with impunity, workers have begun to organize themselves. Right? So the demands and the advocacy has always been there, coming from the worker side, the new forms of workers, that what is it that we really advocated for? We advocated for regulation, that the industry must be regulated. But what was very key to the workers was that they wanted to see that this whole question of misclassification, and I would say a deliberate misclassification, needed to be addressed, that it needed to be clearly regulated and clearly be defined, and that we needed to identify who the enterprise is, who the employer is in this entire contractual and work relationship. And that has always been there. Over and above that, I think in terms of the material questions and conditions that workers were faced with, initially, the earnings were good, but we saw a dramatic and rapid decline of earnings as Uber began to anchor themselves within the South African labor market. All right. They at first had a lot of promotions and all of those things, all kinds of grant schemes. Over and above that, the question of safety was very important for workers. Critically important, because app companies have really, absolved themselves from taking accountability in providing safety and insisting in creating a safe work environment for platform workers, e-hailing workers in this space. Further than that, of course, earnings was very important. And these were the things that we advocated for very, very strongly. In addition to that, one important thing that we advocated for was as related to, just cause and due process related to unfair and unilateral deactivations. In other words, equal and equivalent to dismissals in the space. All right? A rider won't like the way the worker smells or how the worker talks. The performance standards are being controlled through algorithms. If there's a complaint, you are deactivated with complete disregard for the outer-parting rule, complete disregard for the rules of natural justice, no recourse. And this is one of the things that we advocated for. So government realized that the situation can no longer go on, and government engaged in various processes to try and shape regulations that would seek now to regulate the industry and respond to what workers are calling for. And so what happened? There were a series of processes were undertaken by our government. And in this regard, I'm referring now to our Department of Transport. All right? There were consultation processes that were engaged upon. There were various actions through strikes and work stoppages that took place. A lot of people got killed. Obviously, government had to respond and be responsible. And these processes to try and shape regulation began way back. But what happened, and I think our own analysis showed that when the last death occurred at Maponya Mall, we were arguing, why is the regulations taking so long? We were brought in at the tail end of the consultations, and we can demonstrate that. go onto the sites and you will see and read the submissions that were made. You can go and read it for yourself. Clearly there, Uber is quite vocal in the submissions that were made. Clearly there, Santaco and the meter taxis were quite vocal in the submissions. We were then brought into the tail end in a very cosmetic and decorative way into these consultations. Already, the consensus were already reached. All right? So, following the Maponia incident and on the eve of when we were planning to embark on a national action, 12th of September last year, we saw the release of the National Land Transport Amendment Act and its concomitant regulations that follows. And we welcomed it. Really, we needed that. But when we looked at it, clearly, if you do a balance sheet, you will see none of the things and the submissions that we made were actually taken into account. None of it. None of it. In fact, and I'm not going to go into the strict legal provisions of everything because I'm going to bore you, because I'm not a lawyer. But I can clearly see, and we could clearly see what was going on. Yes, we needed this regulation. Yes, there are serious implications for the app providers. For the first time ever, they now have to register within South Africa, which is good. They must have physical offices, which is very good. So they no longer can use, automated responses, through these automated systems where some machine at the other side or computer answers you. They now have to have offices. And of course, they have to comply with a number of other things. One thing in particular that I want to point out that is quite central. And let us bear in mind the intention of the Act is noble. It is to bring compliance. It's to bring safety. We need that. But I will demonstrate to you how it has been weaponized. So, one important focus of it is that platforms like Uber, Bolt, and so on, they cannot operate lawfully within the country, in the space, without the person who is contracted, the operator or driver, if the person does not have an operating license. So the whole amendments are centered in strengthening, the strict requirements and I'm speaking from the perspective, what matters to us, from our perspective, to have an operating license. This operating license are necessary. It has always been there in the Act, in the Principal Act. Minibus taxis, they must have them. Meter taxis must have them. So there was this new amendment, Section 66A, which is the new amendment now recognizing e-hailing as a legitimate sort of mode of transport within the public ecosystem, transport ecosystem. And so this operating license has got strict requirements. All right, and if you do not have this operating license as a driver and they catch you, you face impoundment immediately. They take your car, they don't worry if you have a client in your car. They take you, law enforcement, and you have to pay. You have to pay lots of money to get your car released. But here comes the contradiction. And where the law has been applied in a very selective way. The app companies have been allowed and continue to onboard people who do not have operating licenses. So given the problem that we have of unemployment, it has been exploited by the app companies. They have been allowed, whilst our government was just turning a blind eye in their onboarding drivers who did not have the necessarily full legal requirements to operate. But to leave the Uber office or the Uber hub, you are caught without an operating license, you are impounded therein. Now, how is it possible that the law can be applied only to some and not to others? Let me quickly move on because I think I don't want to get stuck into it. There's a number of other provisions in the National Land Transport Amendment Act that is quite problematic. As I said, it does not address any of the key issues that we've been fighting for. Over and above that, what we have seen is that there's been a very fragmented approach between our departments that were supposed to work in a more holistic way and coordinated way, particularly the Transport and Department of Employment and Labour. Through organized labour, I think they have played a significant role through NEFSA in assisting and bringing about also now some amendments that is filling the gap which is left out in the National Land Transport Amendment Act. And so we now have seen also amendments to the Labour Relations Act, including the Basic Conditions of Employment Act, which seeks to have an expanded definition on employee to cover also the platform e-hailing drivers. But again, there is a serious problem about the way these definitions in terms of the different sets of our labour legislation have been structured. They are not uniform in a sense, and they are covered by different definitions. Definitions differ from one. The Labour Relations Act, for example, now introduces a Schedule 7, which is in a sense, on paper it looks good, but by the end of the day, the rebuttable presumption that has to be applied in determining through a test whether the person is actually falling within the definition of an employee, I think is still quite burdensome and poses a significant challenge for us where we would be forced even into lengthy and costly litigation, which organizations like us who are not well-resourced can hardly afford. So Schedule 7 quickly affords now drivers, if it is proven that you are meeting that test, freedom of association, that we can form trade unions and join trade unions, organizational rights, which are good. It affords also collective bargaining rights, but it does not cover dismissals, for example, except unfair dismissals due to strike action and so on and so forth. But let me just say quickly that what does this for us mean? The social impact of the regulations, I think I want to quickly talk about that. The social impact of this regulations, I think in the immediate term and short term will lead to thousands of drivers without operating licenses being at risk of immediate deactivation, because the department is on record that there are backlogs, that the systems are not ready, the state of readiness to issue this sorely needed operating licenses to operate, without this anxiety. They are not ready yet. So the other question is that there will be national job losses that will be tens of up to 30,000 if enforcement is strictly applied, and there's been no plan to mitigate against that social impact. Medium-term impact, drivers' household incomes may drop in our view from 30 to 50%. Backlogs and poor state of readiness in issue operating license could exclude thousands, as I said. Secondary impacts, increased compliance costs, which are being shifted to drivers now, is one of the provisions in the Act. Now you must have vehicle branding, you must have extra inspections, safety equipment in your car, and so on and so forth. Restricted routes also has been impacted, that you can only drive up to a particular point, and you cannot immediately take somebody from there back again, unless it is pre-arranged from the area where you come from. And so on household income, mass delistings, those are the things which are posing significant challenges for us. With regard to the new definitions, we say so far, we say that, you know, this is still a major problem. There are too many ifs, ands, and buts. And by the end of the day, the rebuttable presumption leads us back to the experience we've had with case C499, which ended up in the Labour Court, overturned on a technicality, and we could not pursue it because of the cost involved to take it to the Labour Appeal Court. Let me conclude by saying that there are a number of international precedents that South Africa can draw from, both the United Kingdom, California, India, who is also exploring policies to extend social security benefits to gig workers without altering their status, of course, as employed and independent contractors. Proposed reforms of Africa has an opportunity to lead in crafting inclusive and adaptive regulations. The following reforms could be considered: setting clearly defined definitions and tests, a relook at the hybrid model, the hybrid classification of dependent contractor, and as we confront that, the legal and technical challenges continue to unfold. South Africa, and also at the level of the ILO, the processes regarding the international labor standards, which is due to be confronted once more during June this year in Geneva. And at the level of these somehow technical and complex engagements, I think there are a number of strategic considerations for platform worker formations, unions, and the natural allies to consider, and even governments that are progressive to urgently seek consensus on. And these may include, but not limited to, what could be considered as the red lines which may guide us to the best negotiating alternatives as we prepare for the next round at the ILC for a meaningful and binding convention. And how do we begin to serve the balance of power in a manner that is sustainable in favor of platform workers, given the power imbalances at the level of the ILC? How do we respond to the consistent efforts on the part of platform providers who are strategically shifting their approach and their business models to escape being properly defined, and now they're introducing what is called the subscription model and moving to the bidding model? Last but not least, how do we begin to set national precedents within our own countries that could form part of a substantial set of benchmarks that could be embodied and written into a code of good practice that can guide us when we come to this year at Geneva lastly on the standard setting process. I will not deal with the other things, but just to conclude on some concluding remarks to say that transport, South Africa is at the crossroads, shaped by the rapid expansion of platform work and the pressing need to update labor regulations, as well as the urgent need to strengthen the collective voices of platform workers and progressive collaborations globally to produce a meaningful, binding ILO convention is critically important and urgent. And defining employees and independent contractors is not just for us a legal exercise, but a moral imperative to ensure that workers are treated equitably and with dignity while platforms continue to innovate, of course, and by embracing thoughtful and meaningful reforms, South Africa can pave the way for a more inclusive, resilient, and dynamic economy that benefits all stakeholders, and thus rise as a leading force to effect a meaningful binding convention at this year's ILC by strengthening our voices in the global south in particular. I thank you.
Thank you so much, Omar Parker. You covered a lot of ground in a record amount of time. I think a lot of issues were raised, which I hope we can loop back to during the Q&A. There were some issues that were also raised specifically for the Department of Employment and Labor around the design, the content of the new amendments, around how they get implemented, how to make them accessible to working class people, how can working class organizations actually leverage those amendments As you mentioned, Omar Parker, it's not just a legal exercise, but a moral imperative. And so it brings me great joy to be able to welcome Stephen Ratai from the Department of Employment and Labor as a discussant, our first discussant. Please.
Thank you.
You can take it.
Thank you very much. Greetings to everyone here.
Greetings.
Thank you. Greetings to your listening. Greetings to old friends, Jane here. Jane has been our commissioners of conditional advantage. And it takes a decade to forget a good friend. Thank you. And I've also seen Kam, who was working with us, Department of Employment and Labor on the job summit. People that you never thought you would meet, but I'm meeting them. Thank you. I think my colleague, or the previous speaker, I thought was encouraging on my terrain. And what I'm going to say, just to say amen. You know, in church when somebody has said what you agree with, what you intend to say, all you can say is amen. And then you sit down. I will not disappoint. Yes. I think my colleague is correct that by saying, look, there are labor law amendments that we have just published for public comments. The two bills, your labor relations amendment bill and your labor law amendment or employment leaders for Concept or Benjamin. And these two bills are an outcome of network processes. And you would know the network processes is constituted of organized labor, where you are represented, organized business. It's unfortunate constituency is not there. I know Jane will lament after this meeting, we're not part of it. And government. Therefore, it's a product of social dialogue and consensus by social partners. At times as government, how we measure ourselves is when labor is complaining. When employers are complaining, then we thought we have struck that balance between labor and employers. And rightly so, my colleague is correct to say the deeming provision and the definition in the some of our legislations. And if you compare that with the Constitution, you would know the Constitution, Section 23, speaks about a worker. But when we deal with workplace issues, we speak about employees. Maybe that's the challenge that we still, and I was looking forward, and we thought that as a department will support platform workers when they were challenging. There was this issue that went to the CCMA about their classification, and the department was willing to back that case just to get that land from the Constitutional Court. It would have been interesting to check whether Constitutional Court speaks to the concept of an employee or it goes back to the what the Constitution says, the concept of worker. And I guess it would have been interesting. But as I've said to you, colleagues, we have published two bills, which we have also submitted to Parliament for public comments, and were published for public comments. And these bills, their intention, amongst others, is to regulate platform economy. And by platform economy, we all know it goes beyond Uber drivers, you know, workers, we call what 60, there's quite a number of people that we intend to regulate in terms of these amendments. And the intention is to deal with that misclassification, you know, to say people who are workers or in terms of our legislation, employees, to say, no, they are misclassified, they are not independent contractors. For example, if you want to know what is an independent contractor, we say plumbers, they are independent contractors because it's somebody that you pick up your phone, you call that person, there's nothing that you control or doing anything. He or she does the work, then you agree the fee, and then that person goes. There's no control, there's nothing. Therefore, that's what we were intending to do. Now, my colleague has already stated that in terms of the bill dealing with platform economy, we come up with presumption clause. And it's not new, this presumption clause. It's already there in the legislation, but on labor broking and on labor broking, what is it? Temporary employment, so to say. But it did not fit this context that we are talking about, the platform economy. And you would know when in 2015 we came with this labor law amendments precisely because we wanted to deal with atypical forms of employment. And you can see the labor market is changing. The more we amend the legislation trying to correct there are new forms of employment that are coming up. And that's where the question comes up, that the instruments that we are using, they are correct or not. And as the Constitution is saying,
precisely because we are talking about we must now and then catch up.
Now let me talk about these bills. In terms of the labor relations, as my colleague have said, we have, in terms of this law, come up with a presumption. And the burden of proof is on the platform employer, so to say, or the employer or the platform to come up with this presumption. Yeah, I think the presumption deals with three things. What should happen in terms of the presumption to see whether a person is an employee or not in terms of this is that there are three conditions, as I've said. If somebody or a person is subjected to control or direction of another person, that's what you test in terms of this presumption. Then you conclude that person is an employee. Secondly, if it's a part of that organization, and you can't dispute that platform workers are part of that organization, they are controlled, they are managed by algorithms, as my colleague have said. That's another test that you use whether to determine whether these people are employees or not. And the third one, I'm trying to run now. If somebody's performing work for a customer, but he's directed how he or she should perform that work, you would know people who are working for courier companies. I remember there was someone who was coming to me. It was around 5 o'clock and I wanted to leave. And that person says, no, I'm coming. I said, no, come tomorrow. It's too late. I'm leaving. He says, no, I'm not allowed. I must come to. Even people in 60, they are controlled. The time they must leave, how fast they should be. Now, in terms of this presumption, you see they are classified as employees. But again, it's up to the platform or the employer to rebut that presumption that a person is not employee. And I accept your criticisms that might be costly, especially for vulnerable workers. But again, you would know that in terms of these amendments, particularly in the BCA, basic conditions of employment, you also regulated 0 hours workers. 0 hours workers, precisely because you would know the industry also uses these workers. They are called, and sometimes, especially when you do this, delivering goods and what, you are there, and when there's nothing for you, you are not even given notice. You are told, no, there's nothing, you must go. Therefore, in terms of these amendments, we are also regulating 0 hour workers who are coming, and should somebody or an employer tell you that today you are not needed, you will be paid for that day in terms of these amendments. And then also the law requires that there should be a period. You must know your working hours, the days that you will be needed, and then a cancellation period. You can't cancel now. There must be cancellation period. But also what I want to correct, because what my colleague have said, he said these amendments are not going too far. There are people excluded. Immediately when you are accorded this rights, you have a right even to appeal the system for unfair labor practice, unfair dismissal. You are covered by the basic conditions of employment. You have, we are moving away now from maternity to parental leave. You will be covered in terms of parental leave. You will be covered in terms of overtime, all what the legislation accords to all workers. When we use this presumption and employers are found that you are a worker, and I'm not sure how will the platform avoid these presumptions, because even if algorithms, we know, as my colleague have said, they control you, they can cancel, you are what you call appraised in terms of your performance, all these things. It doesn't have to be a human being, but the algorithms themselves, when they do these things and then they cancel your contract, you can challenge it. Thank you very much.
Oh, thank you. Again, lots of questions raised, and I hope that we can come back to them in the Q&A. Thanks so much. I would now like to invite Muzi Simelane, who is online. He's representing the Department of Transportation. I think what you're seeing in terms of the regulatory landscape is that there have been attempts to regulate particular sectors. So for instance, in Kenya, they did the National Transport and Safety Authority Act that was specifically about amending that act to respond to the e-hailing sector. But as you said, it leaves all these other workers outside. So what South Africa has tried to do through amending the Basic Conditions of Employment Act and the Labor Relations Act is to try to extend labor and social protections to all gig workers, regardless of what sector they're in. However, there have been also, as we heard earlier, sectoral initiatives, one of which was with the Department of Transportation. I hope, Muzi Simelane, that you were able to hear some of the critiques that came from Omar Parker, from the E-Hailing Association around the content, but also a recognition of the importance of that regulation in terms of establishing some, I think it was, Omar, you said order, or, within the sector, this emerging and rapidly evolving sector. So without further ado, I'll turn it over to you, Muzi, for a response, and you have 10 minutes.
Thank you so much. I'll just take from you, Chairperson, from your point where you said Kenya as well had to respond to amend their legislation so that then they can regulate the e-hailing service. We did a similar exercise around 2010, 2011. That's where it started, because we just we were overtaken by the event that we found that this technology, which was coming through Uber, it was already in our public transport space. We already saw and experienced. There were already a lot of violence that were happening on the streets in our public transport space. So then Parliament as well was then asking the minister, the national minister, as to what is this new service that is now on our street and what is the minister is doing about it. So we then started an amendment act to include the e-hailing service, which was a technology which is much more involved than an ordinary meter taxi service. It uses such a sophisticated technology. So there was a lot that needed us to consider in the amendment. Unfortunately, it took, the parliamentary process took so long. It's been a 14-year marathon, which take very long because of other matters that the president found them that they were unconstitutional on the Amendment Act. Yes, so in public transport space is two things that we're doing. We regulate public transport because in South Africa, you are not allowed to ferry passengers for reward without an operating license. So then we use the National Land Transport Act to then regulate, to say whoever is coming to operate or provide public transport service to the community, he need to apply to the provinces provincial regulatory entity offices in the different provinces for an operating license. That is one. Then secondly, in terms of the National Road Traffic Act, we then look into the roadworthiness of the vehicle and the qualification and the fitness of the driver, that he must not have any criminal record, he must have a PRDP, he must have his driver's license, and that the vehicle must be roadworthy to be in the road. So those are the two fundamental legislation that we are using in South Africa. And then the other third thing is, in South Africa, it's only vehicles. I need to emphasize this, Chair. It's only vehicles, motor vehicle, minibus, midibus, and bus that are allowed to ferry passengers for reward. We're not gonna start regulating motorbikes. Now we've just seen now that Uber has introduced motorbikes as passenger transport. In South Africa, that is not allowed. It's illegal. I don't think we're gonna start to regulate it, or we're gonna run another amendment to include motorbikes. It's a very healthy, sensitive matter in South Africa, or the issues of helmet, etc., etc. So we can go through the National Road Traffic Act regarding that. So now this amendment, then it was passed last year, 11 September 2025. So we started to implement. In our implementation, the teething problems was that we wanted all the app companies to register with the national government in Pretoria so that we have a control, we can regulate them and know who are these apps that are in the country. More so, we want them to be naturalized, to comply with national legislation, to comply with South African laws. They must have a physical address, they must have companies that are registered in South Africa, then they must have an office where operators can go and make some queries and get some contacts with them if they've got some problems. So now that is where the delay has been. The app companies have been very slow in complying with the regulation. So the 180 days has passed in March, on the 11th March this year, which we had given them 6 months for everybody to comply. The compliance was in two folds, that all app companies, they register at the national level, and also then that once they've registered, then operators who were operating with an interim measure of a charter license or a meter taxi, they need to go back to the provinces to convert those licenses for their natural e-hailing service licenses. So then the app companies have delayed in their process of being registered at national. So now I understand about, I think 7 or 8 now that have been registered officially. So, however, with that delay in mind and understanding that operators on the ground have not gotten enough time to then comply, to go apply for their requisite operating licenses, we are then writing to the minister to extend the compliance period. We're going to give them again for another 180 days, which is another 6 months, for all the operators now to go back to the provinces where they are operating, then to apply. So that is where we are at the moment. I'm just waiting for the minister to sign on a notice. Then we'll take it out on the government gazette and communicate to everybody. So then, therefore, with the comments and the queries that Brother Omar was raising, I think the PREs have not been totally tested yet, as I'm saying that they've since been waiting for all these app companies to be registered under the national government, under the NPTR. So the real test of that, we're gonna start seeing it now going forward, as this, I'm saying 5 or 7 apps that have now been registered. Then operators will now be allowed to go then to convert their operating licenses, though that needs to convert, and those that need new operating licenses for e-hailing service, they will also go then to apply for the e-hailing service licenses in the provinces. So this is where we are at. Unfortunately, always the government system, there are always teething problems and they are slow for an uptake. But yes, that is where we are. So we are appealing and hoping that these provinces also, they will then pass the similar message for law enforcement so that they suspend, they are on a moratorium on impounding of vehicles. on all the provinces and the cities, that they must understand. So where government is in regard to this, so that then the law enforcement as well, they understand and be at least understanding to the operators on the ground if they are on the road already without an operating license. So this is where we are. I don't want to talk much. Maybe that is the long and short of it, where we are. We are regulating. This is where we are at. So we will see the actual test of the regulations now as the provinces now will start to be engaging with the operators. The challenge is that also in the provinces, there are also backlogs of other services like your meter taxi, your minibus taxi type services. There are also a lot of backlogs also with regard to that. So it's not like when the operators go, the e-hailing as a new industry, they will get priority as such. But the provinces will have to deal with all these backlogs that are sitting on their table. So that will be the challenge. That will be testing between the operators and also on the side of government, that then they need to work together in understanding with that predicament. And also then the challenge as well will be, the test now will be also on the provinces and the municipalities, how they manage the numbers, because we don't want to flood the streets with vehicles. The e-hailing service industry, they must not now think that they are the only public transport service that are available in the country. The streets in South Africa, they are heavily guarded by the minibus taxi type services. So we need to make sure that we control the number so that then it's not flooded now with vehicles like in the minibus. It has happened every corner of the street. You find that there are parked illegally, erecting illegal in ranks for them to park, so that then they can go pick up passengers where they need to go at a rank space. So that will be the test, the real test for government now, from the provincial side and also from the local authority side. At national legislation, we will be monitoring the implementation and also these apps, if they are compliant with the national legislation. That's the long and short, Chairperson. I will then pause, maybe answer questions as they arise. Thank you.
Perfect. Thank you so much. It's useful to get insights into the kinds of experimentations and adaptations that are happening within the regulatory space, particularly in relation to transport. Of course, this all raises questions around power in the digital economy. Who is bearing the burden? Who's making the gains? And so I'd like to invite Lanley Simpson to reflect both about platform, but also, about the broader questions around digital economy. Lanley is with the Department of Science, Technology, and Innovation.
The first thing I want to ask is somebody. I just want to say, firstly, from the outset, the taxi industry and e-hailing industry is not public transport. It is private transport providing a public service. Do not confuse the two. And a lot of people mix the two up. And therefore, by its very nature, it is extractive. Because it is private transport. And people tend to talk about this as if it's public transport, but it really isn't. And you can go back into its history. But we understand it is effectively a mafia control type system. It's the same problem that Hong Kong had in the 1930s that eventually led to a plan to try and break the nature of what it was as an extractive system. So the key question becomes, how do you deal with something which effectively is so entrenched, it was set up by Hendrik Skuman as a mechanism to privatize the sector and create freehold black businesses in South Africa at that particular stage. So the key question becomes one of, if it is regulated in a particular way where the drivers or the workers have no power, even in the e-hailing industry, South Africans are very innovative. Somebody sets up a company and buys a whole fleet of motorcycles that they then hire out to people at particular levels, and then they have to pay for that through all this money that they supposedly earn to pay for those vehicles that they actually don't own in order to operate. None of that's been dealt with within the legislation. So I'm saying people must understand South Africa in relation to its the mechanisms of coercive rent seeking that occur within its operations. And that must be dealt with at various levels within the system. The first thing I want to say is my department. My department, unfortunately, has what I call a techno-optimistic paradigm, which prioritizes innovation over labor. The policy frameworks treat the platform economy as a vehicle for innovation, global competitiveness, digital inclusion, and entrepreneurship. However, this reflects a productivist neoliberal development logic, where digital technologies are framed as neutral tools for growth, labor is subordinated to innovation ecosystems, and the state acts as an enabler of markets rather than protector of workers. Of course, this fits with the whole 4IR issues, where technological adoption is prioritized without adequately restructuring labor relations. The problem with the DST is that it reproduces what the heterodox traditions call technological solutionism, assuming that digital expansion will automatically generate inclusive development, despite historically entrenched inequality in South Africa. The issue, of course, and the critique of this is that leads to a labor critique, which effectively is a form of digital tailorism. Where as opposed to the frontline worker that you have, or the foreman that you have, that manages and supervises the workers, what you have now is an app. And the app controls the worker. And the app fires the worker or deactivates the worker because of the way the algorithm operates. The labor amendment bill that's referred to has a rebuttal presumption within it. But the employee does not have the kind of funds required to fight that rebuttal. It requires huge amounts of lawyers compared to these platform owners, who, by the way, are not based in South Africa. These platform owners, Booking.com is owned by a Dutch company. Travel Starts is a Dutch company. Airbnb is an American company. They're not based in South Africa. And while they are required by legislation, the ability to actually contest something, if you do not get your delivery, who do you phone? You can't phone anybody. You're supposed to deal with a chatbot on the app. That's a problem. So in effect, the app becomes the digital version of the foreman. There's a lot of information I'm trying to, because I can't say everything within 10 minutes. I put it on the slides. So hopefully you can follow some of the ideas that are there. That then brings us to the issue of what becomes data colonialism. So the draft national AI policy has just been published. Please, it's there open for public critique. There are lots of problems with it. The POPI Act also attempts to regulate this, but neither of them address the issue of data sovereignty or the notion of a sovereign worker, if you want to go in that route. Sovereignty we can debate. I don't know if it's a good idea or not. The big question is, are countries a good idea? That's another story. So the key question becomes, in relation to this of extraction versus value. Digital platforms extract massive amounts of behavioral data from townships and cities. This data is processed in the global north by these systems and platforms. They're to refine their AI models, while local data subjects see none of the surplus value. Regulation currently focuses on privacy. However, they should also focus on transparency. Workers have no right to see the code that determines their search pricing or their route efficiency, leading to an information asymmetry that favors the platform owners. The next issue is the Competition Commission. And the Competition Commission is really, who's it protecting? The SMMEs or workers? And the whole inquiry that they conducted in other words, they have stopped platforms from self-preferencing, and they actually are supposed to focus on entrepreneurs who are historically disadvantaged. And one can go in, what is their primary goal, the target, the data, and the ultimate outcome is, in effect, that the Competition Commission is focusing on a more ethical capitalism, as opposed to reclaiming the means of digital production. This leads, of course, to a decent work deficit. The ILO defines decent work as involving security, fair income, and social protection. In the South African context, with 41.1% unemployed in early 2026, the platform economy acts as a vent for surplus labor. It's not addressing the unemployment issue. The reserve army of labor. Because so many are desperate for work, platforms keep wages at subsistence level. The state's regulation is a light touch because it fears that strict labor enforcement will cause platforms to exit, worsening the unemployment crisis. Gig workers still lack access to unemployment insurance, medical aid, and pension schemes. There's a demand that platforms contribute to a social security fund for all digital workers, regardless of their so-called contractor status. And the alternative, maybe we need platform cooperativism. Regulation is not enough. The ownership model must change. Instead of Uber, why not a worker-owned taxi app supported by the state? In Ireland, they have that. Uber's not allowed in Ireland. All those workers who actually are e-hailing drivers under the app, which is controlled by the state, have access to social security. I spoke to one of those workers while driving with him. I picked him up to the airport, and he said this is what they actually have, and the full range of benefits are provided. Instead of checks at 60/60, why not a municipal delivery cooperative? This critique suggests that as long as digital infrastructure is privately owned by foreign capital, decent work in South Africa will remain a mirage, perpetually undermined by the platform's need to extract profit from shareholders in San Francisco or Amsterdam. The Pretoria Action Plan, which came out as a result of the competition's work, is a step towards this cooperation, but without a specific focus on the South African class struggle, it risks becoming another bureaucratic exercise that reforms the platform economy without empowering the actual people who power it. In effect, that's a summation of how one could regulate and head towards something that incorporates digital work, that incorporates social justice and the transformation process. The last part I want to get to is effectively on the nature of the department I work for. And the issue is, in effect, sorry, I'm also an active citizen. I don't, while I'm here from the department, I also have the right to critique the department I work for. Good. So the problem with our department, the focus on innovation and all these technologies, and I run the whole digital economy development process. The department's approach reflects a fundamental contradiction. It seeks to build a high-tech economy on top of low-wage, insecure labor conditions. This is unsustainable. Economically, there are limits on demand and productivity. Socially, it deepens inequality. Politically, it undermines legitimacy. The regulation of the platform economy itself, particularly as influenced by the DSTI, is marked by a pro-innovation, insufficiently labor-centered approach. While digital technologies are promoted as engines of growth, the labor relations they produce are often precarious, informalized, and weakly regulated. This critique exposes this as a continuation of neoliberal restructuring, a new frontier of labor exploitation mediated by technology, and a missed opportunity to align digital transformation with digital work, redistribution, and social justice.
Thank you, Lanley, for this aula magna that really pushes us to think beyond regulating at the edges, to consider seriously the question of power within the digital economy and what the implications are, not just for one particular sector, but for employment, for development, for well-being in South Africa. And we have many in the audience that are from across Eastern and Southern Africa, and I suspect that actually many of the issues that have been raised are quite similar. But before we go into Q&A, I'd like to turn over to Pat Horn, who has many different hats, was co-organizer of this particular event through Women in Informal Employment, Globalizing and Organizing, has been working with informal workers across the continent through the network StreetNet, sits on NEDLAC, the tripartite or quadripartite body in South Africa, and has been privy to many of these conversations. And so, Pat, over to you for a reflection or a response to our discussants, and also to what Omar was raised. Thank you.
Okay, thanks very much. I'm not going to the podium either. So I think it was so great to hear from 3 different government departments. And seriously, what we need is a continuing collaboration between particularly these 3 departments, because we can hear that they were addressing 3 different aspects with different kinds of legislation. And I think if these 3 departments were to work together, in principle, what I would like to see at the International Labour Conference this year is a South African government delegation having people from those 3 departments. We know that the Department of Labour is the lead department in ILO events. But, you know, when we have something at the ILO on mining, we normally have people from the Department of Mineral Affairs, as well as the Labour Department. So I think this is something that we need to, certainly I would be raising that in NEDLAC. I think to get onto the, onto the thing which we are facing, and what I'm looking at is the angle of the workers in the sector who are getting organized, as we've heard, are holding out some hope that the International Labour Organization is going to come with quite a strong convention which will recognize the workers as workers, not employees necessarily, because the misclassification issue is the key issue which is allowing the platforms to dodge all of their responsibilities. And I think the way in which it was described by the Labour Department is when they are looking at who would be workers, it's basically people who are controlled. And that is the key issue. So you can be controlled even if you don't have an employer. And so, and this is what this convention is attempting to do. The ILO did, in 2002, develop a definition of own account work. Own account workers or self-employed workers who don't work for an employer or not a single one. They might work for several different ones at different times, but they are controlled by some or other entity. In this case, it's an app. Others, it can be the municipality that they work on, like street vendors and waste pickers, etc. The problem with the definition of own account worker, which we had to fight for very hard, by the way, it even took a vote. Many governments have not managed to exercise those rights in their laws, and our government is struggling with that. We have labor relations laws that are very confused in their language. They interchangeably use the words worker and employee. The minute you use employee, you're talking about a small group of workers. And all of the ILO conventions are supposed to apply to all workers, including own account and self-employed workers. And that includes the right to freedom of association and collective bargaining. But the collective bargaining is not really happening with those kinds of workers. So I think that as we prepare for this convention, of the platform workers, the sector which is the best organized is the transport sector, hence the IAATW that Omar is representing here. Is the best organized, but there's also a lot of hidden, isolated, mainly female platform workers that we've been discovering through feminist networks that have not been able to organize themselves as strongly as the transport sector. So the transport sector is helping us to identify the issues for this thing, but in fact it goes a whole lot broader than that. And the convention, in principle, is directed at all those kinds of platform workers. So, of course, it's not only transport, but our transport department is the one that started to do legislation for it. Other departments will have to follow suit. Then I think that what we should be doing, and certainly what we would like to see the Department of Employment and Labor doing, is just getting consistent language. When there was a Minimum Wage Act, which was more recently developed, that one is consistent. It uses the word workers. And you know what? In the countries that are Francophone, Lusophone, or Spanish-speaking, they don't use the word employee in their legislation. They use the word worker. So if they can use the word worker, I don't see why the Anglophones cannot follow suit. But it has something to do with being dependent on lawyers who've been through Anglo-Dutch law, and they have problems with using the word worker. But I think we have to get over that problem, because it's also a very divisive issue, and it makes it quite difficult even among platform workers, where we find the European Union desperately trying to exclude own account workers from the Platform Work Convention. Luckily, the workers group is quite determined, I would say, to not create those kind of divisions, and that convention in the end is supposed to apply to all the workers. So I've just made those comments because that's what faces the sector between now and June. But I think after now and June, I really like the example that was mentioned about the worker-controlled taxi app controlled by the state. Now, we know that a lot of taxi companies are cooperatives in many countries, Colombia, Brazil, etc. But there's two African countries where something similar exists. It's Namibia and Togo. So Togo got rid of Yango, the main company they use in the Francophone countries, and put a state-controlled app. And Namibia apparently got rid of Uber. They do still have some of the other smaller private apps, but to put in place a state-owned one. And I do think we need to look at those kinds of models for the sort of post-convention hype period that we're going to be working on. Thanks very much.
Thanks so much. And finally, I wanted to welcome Mavis. Are you on? I think.
Mavis Kohositze.
Yes. From SATUC. SATUC was really important in the early days of organizing in the e-hailing sector. And I think that there's an interesting relationship between SATUC and the emerging e-hailing workers organizations. So Mavis, over to you for a response to the comments so far.
Thank you. Thank you very much, Chair. I'm pleased to respond on behalf of SATUC and in partnership with WIEGO, as Pat has already spoken, which is an organization that has long shown us how to organize in the informal and precarious economy. I've listened carefully to the discussants, and I just want to thank them for their rich contributions. And what I'll do is to reflect from a Southern African regional perspective, grounded in what our affiliates, SATUC affiliates, say across in the 15 SADC countries. What they are telling us, including recent developments in not only in South Africa, but in Botswana, in Namibia, as already mentioned, with Yango and InDrive, emerging in those countries. The discussants have rightfully highlighted the precarity of platform work and the problem of misclassification and the need for algorithmic transparency. So what I want to add from our perspective is that platform work is not identical everywhere. In Southern Africa, for example, we have very weak labor inspectorates, high informal employment, cross-border cross-border platforms operating without accountability, and workers who often juggle platform work with informal, vending or piece work, as we call it. And there's also largely a lack of regulation, because this is a sector that is emerging really fast, and we need to also be very proactive in terms of making sure that we can equally make sure that these workers are protected. As Pat was saying, for us, the ILO Blue Report is an excellent evidence base, but we need to translate it into SADC specific actions. So how do we use that Blue Report? For us, it is a toolkit that SATUC can use to translate it into some kind of know your rights guide for platform workers in every SADC country. And we will use it to draft, some kind of model legislation for our own parliamentarians, and use it as an evidence to pressure the SADC to harmonize labor protections across borders, because that Blue Report is our global evidence, and our job is to turn it into local power, as you had mentioned, Chair. The beautiful part about SATUC is we do have a structure called the SADC ELS, SADC Employment and Labor Sector, where SADC Ministers of Employment and Labor, business, as well as trade unions meet, to social dialogue, and also, to come up with, legal frameworks that support decent work in Southern Africa. So within that space, then we would be able to put forth word to say, in this emerging sector, what sort of framework do we want to see in order to support platform work? And let me give a concrete example. For example, in Botswana and in Namibia, and I think Zambia as well, platforms like Yengo and InDrive are now operating in Gaborone, in Windhoek and surrounding areas. So our affiliates actually report that drivers are classified as independent contractors, that there are no minimum earnings that are guaranteed, and that there is no fair calculations, calculations in terms of fair are very much opaque, and that deactivation can happen without any appeal. But yet these drivers are doing, the work every day, and that is room for us as trade unions to begin to organize them, and one of the questions that we get is, how do we make sure that we organize them? How are we going to do it? Because they are not in a traditional workplace. So, but there are various ways that we can learn from other people, where they use WhatsApp groups or informal meetings, and that more and more of them are now beginning to reach out to trade unions. So this is where SATUC and WIEGO must step in together. And as I said, our role as SATUC at the regional and also at the national level is that we are already acting, we are already engaged. We were in the past ILC, where we strongly, advocated for a convention, and that now with the Blue Report and going into this ILC in June, we need to really prepare such that everyone that is going to the ILC who represent workers really can go there with one position. So at the national level, we will support all our affiliates, what from Angola, to Botswana, DRC, Zambia, right up to Zimbabwe, to engage with platform workers, and also to advocate for national legislation on employment status, because that's one area also where we find that there's a bit of ambiguity. At a regional level, it's very important that we develop a SADC framework on platform work. We already have the SADC protocol on employment and labor, but I think in time we can actually look into it and see if there are any provisions that in there that can accommodate platform work. And we are also already engaging and facilitating cross-border solidarity, because a driver banned from Yango in Botswana may try to sign up in South Africa or in Namibia. So with our 22 affiliates across 15 SADC countries, and especially with affiliates of our affiliates within the sector, that is a network that we can move, quickly to make sure that we do organize these workers. But what I must say is that no one organization can do this alone. So as SATUC, we emphasize that it's going to be very important for us to continue collaboration, knowledge exchange, and global networking. That is hence why we are constantly talking with PET, WIEGO, and ITF, combining WIEGO's research and organizing tools with our own SATUC's research, regional research, and then knowledge exchange across the regions. What works in Kenya or Brazil may work in Botswana. So we are, working to ensure that we can set up peer learning exchanges. There's also global networking, as I've said, through ITUC Africa, UniGlobal, and all the other global union federations that we can talk to and organize platform workers, and make sure that we also have platform worker networks in Europe and Latin America, so that they can actually be, comparisons between not only between the continent and what happens elsewhere, like South-South, Global South, Global North, cooperation. That's what we usually call it. So we must stop reinventing the wheel and make sure that we can actually share what already works. So in closing, I think this is, I think we need to have an honest, conversation. And my honest observation is that, for too long, unions have been missing, from the platform economy. We have not been where the work is. And to be frank, many platform workers do not yet see themselves as workers in the way that our traditional membership models, expect. So they see themselves as independent, as hustlers, as their own bosses, because that is what the platforms tell them. But I think we need to change that narrative. And SATUC commits to closing the gap through, our affiliates, as I have said, across, SADC countries, and make sure that we can strengthen organizing strategies that meet platform workers where they are, digitally, informally, and on the move. In the past, we used to have SATULA, the SATUC Academy, where we had training programs. So I think we can, even take advantage of the digital, work that we can reach any worker anywhere and have an educate platform workers about their rights, starting with the ILO Blue Report that I've mentioned. National labor laws, as has been mentioned, if they need to be reviewed, they need to be reviewed. And the simple truth that collective power is the only real, counterweight to an algorithm. So, but unions cannot do this alone. Social dialogues must include all intersecting ministries. And I'm happy that in South Africa, we do have those ministries that are present, not just labor and transport, but also communications, digital technologies, finance and trade and industry platform work, cuts across all of them. So let us move from, dialogue and binding commitments. I think Pat, always hears me saying all the time that we can write statements that we are, known for as trade unions, but let us go beyond just issuing statements. Let us move into action that translates into positive impact for the workers that we represent. At SADC level and within individual countries, before the ILO convention is finalized, let us have, dialogue and binding commitments. So yeah, I think that's all that I have. Thank you for this frank and forward-looking discussion.
Thank you so much. Collective power is the only counter to algorithmic control. And let us move beyond simply words and think about action. I think that that's a really great challenge for this last half hour. Now, I know that the chat has been very active. There's lots of hearts I'm seeing here on the chat. There's lots of questions. I want to start with a question to each one of the speakers, and then we'll collect a round internally, and then you can answer them all collectively, and then we'll do a round online. For Stephen, we've spoken about the definitional issues, but I actually wanted to ask you about what the next step would be in terms of implementation if platform workers are found to be employees. Would it be the definition of a sectoral determination? Would there be space for bargaining forums? Does the kind of South African innovative approach to collective bargaining, where you can extend a bargaining agreement to an entire sector, is that a way of allowing for workers' voices, for taking into account the specificity of particular sectors while also having a sort of regulatory impact? You know, how do you expand it? How do you ensure that regulation doesn't undermine workers' agency and flexibility in the process? What have we learned both from sectoral determinations and collective bargaining? Others can answer these two, but I'm sort of to Muzi. I think you're still with us. There's a question that comes up in the chat around compliance. How do you hold multinational corporations to account? In Kenya, we saw after the adoption of the National Transport and Safety Authority Act, we actually saw the NTSA suspend Bolt for non-compliance. In this case, it was non-compliance with the cap on commissions. So I'm just wondering if you could talk a little bit about the kind of enforcement tools that you might have at hand, and how you anticipate, I suppose, addressing some of the loopholes that platform companies may sort of be able to take advantage of. Because I think what we see is that the platform business model is one that's very dynamic and constantly evolving. So I suppose that's a question to you. Lanley, I wanted to pick up on the alternatives and the cooperative, and to sort of reflect on the role of regulation in making it possible for alternatives to succeed. One of the big challenges with multinational corporations is that they're able to draw on venture capital funding in order to outcompete and eliminate alternatives. And I think that poses a real challenge in terms of being able to foster sort of innovations, cooperatives from below, unless there's some kind of government action that equalizes, I guess, the space. And so is regulation, I suppose, part of, to put broadly, industrial policy, you know, or ways of sort of promoting endogenous alternatives? Pat, you are in these processes, you have a long history of being in these processes at the global and national level. One of the things that strikes me about platform work, in contrast, let's say, to other informal sectors, is that because platform companies are involved, the debate on quote unquote formalization of the informal, if we treat platform work as informal, comes up right against the power of capital. It's quite different, let's say, to street trading, where the debates on formalization were about government. Usually the onus was always put on government to provide public space, to offer social protection. And capital, it really left capital off the hook. So do you see this in the negotiations, a kind of a different conjuncture of power? And what are the implications for what is required, I think, as Mavis said, in order to actually advance progressive regulation? And finally, to Omar, I wanted to push you on something. The collective bargaining aspect, I think you didn't speak to here, but how are you envisioning the role of workers' organizations, platform organizations, in collective bargaining processes? Does the collective bargaining architecture in South Africa need to shift? Because ultimately, to echo Mavis's point, only through collective bargaining, the reason that algorithmic management has so much control is because there is no collective bargaining, right? There's no regulation. That's what gives algorithmic management the power it has. And then Mavis, I just wanted, I was curious about sort of next steps. We have an audience here from across Eastern and Southern Africa, including the employers organization from Tanzania that will be at the ILO negotiations. And so I don't know if you can give us a sense of how people can get plugged in to these regional and continent-wide processes. So one question for each speaker, but I'd like to take some questions from the audience. I saw Lubinda had his hand up first, Hamida second, and then you and me.